time clock so that I don't subtract before we start. Attorney Ender, I believe you're here on behalf of the appellant in this case. Am I correct?
You are correct, Your Honor.
And I would keep my representation made earlier this morning by asking you, would you like to reserve any time for rebuttal?
I would please 5 minutes. Thank you.
Thank you. Okay, I think everybody, by the looks of my screen here, is ready to go. Attorney Ender, the floor is yours.
Thank you. Good morning. Catherine Ender from Dinsmore and Scholl. I'm here on behalf of Citizens Property Insurance Company. The issue that I would like to address with the court today, or maybe more appropriately, the elephant in the room, is the Florida court's interpretation of the scope of coverage for direct physical loss under an all-risk policy of insurance. There's really become this mantra in the insurance world that an insured need only present evidence of damage that occurred during the policy period in order to establish coverage. And that's ultimately what happened in this case. The jury instructions here specifically stated that plaintiff need only prove—
Our court has about 5 or 6 cases that hold what you just articulated, isn't that right?
that they do, Your Honor, yes.
So what do we do about that?
This case is factually and legally different from the cases that Your Honor's suggesting. And also you wouldn't need to recede. They actually work really well together. So Fayad, which is the Florida Supreme Court case back in 2006, specifically identified the fact that an all-risk policy is not an all-loss policy. And if you even look back to Hudson, which is a 1984 case that all of the parties rely on, it specifically says—
Counsel, sorry for interrupting, but what you just said then suggests that the case of Mejia was improperly decided because that turned on the fact that it was an all-risk policy.
No, Your Honor, and I'm not trying to say that this is not an all-risk policy, but—
Well, you just said that there's a 2006 Supreme Court case that said an all-risk policy is not an all-loss policy, but isn't Mejia basically saying all-risk policy, all you have to do is prove property damage?
Well, under the facts in Mejia and under the policy language in Mejia and the statute that was in effect at the time that Mejia was decided, an insured only needed to establish direct physical loss due to sinkhole loss. So really, you've
argued that the statutory change should change the burden of proof on these cases, correct?
It changed the quantum of evidence necessary for the plaintiff to satisfy their burden. It did not shift the burden, which is what the insured is suggesting here, but it did change the quantum of evidence that is necessary to satisfy the plaintiff's burden. The plaintiff, under Hudson versus Prudential, even the plaintiff, the insured, acknowledges that once an insured establishes a loss, it has to be apparently within the terms of an all-risk policy. Here, if you look at the terms of the policy, you have to establish more than just a direct physical loss. The insured has the burden to establish a quantum of evidence that is not only damage to their property, but that damage falls within one of the 5 enumerated categories of sinkhole loss and structural damage as defined by the statute in this case. So the statute—
and let me just say, I appreciate the argument. The difficulty is the case law still seems to be talking about structural damage as an exclusion, that you have the all-risk policy, you have an endorsement that adds coverage for sinkholes, and yet the case law says that's really an exclusionary addition, narrowing or addressing what can or can't be covered as an exclusion. So I mean, I appreciate the argument you're making. I'm just having a bit of difficulty reconciling it with the way case law has treated hurricane addendums for coverage to policies.
Well, Your Honor, I think that this, an off-the-cuff example that I can think of in the context of first-party insurance coverage that the courts have dealt with in the past is an example of water damage, where water damage is excluded except for when it's not. And there's the no peril created opening exclusions where there needs to be a covered peril that causes the damage. This is a causation issue again. So, and if you want to use the term burdens and burden shifting, the plaintiff has the burden, the insured has the burden to show that there was damage. The burden then shift to the insurer, to establish that there's an exclusion. To bring it back within policy coverage, the insured still has to show that it fell within the exception to the exclusion. Now, I'm not saying that this is an exception to exclusion. What I would like for the court to hold is that under the policy language and the coverage provisions in this case, which is how the laws interpreted this endorsement, an insured has to do more than say, I have damage. The insured has to come in and say, I have damage that falls within one of these 5 enumerated categories. That's not shifting the burden. The burden still rests with Citizens here or the insurance company to show that there's an exclusion that applies. But insured cannot come into trial and just simply state, I have damage and meet their burden. And that's really ultimately what happened in this case, is that we have.
But that undermines your argument then that we don't have to recede from Mejia, because Mejia basically says exactly that if you've proven you've had property damage, now it goes to the insurance company to show it is excluded under the language of structural damage.
Except for the fact, Your Honor, that Mejia was decided under a different statutory provision. It was decided.
I don't think so. Mejia was decided in 2014 and the statutory changes were in 2011.
Correct, Your Honor, Judge Black. The Mejia, though, was based upon a policy that was issued back in 2009, I believe was when it was issued. And the statute that was applied by the court in Mejia was a 2009 statute. So it was it was. It's at page 579 of the opinion, 627-706 subsection 1 from 2009. So the damage in that case was prior to the implementation of the 2011 statutory.
But you agree that both statutes reference structural damage?
Both statutes,
structure.
Absolutely, Your Honor, both statutes.
So the question becomes, was the change to the statute that says, here's what structural damage is, does that actually change the analysis? And the subsequent cases seem to say, no, it doesn't change the analysis.
Well, Your Honor, I think that this is the first opportunity that the court has had to write on this issue pursuant to the subsequent changes in law. The intent of the legislature was clearly to change the court's determination and interpretation of the term structural damage in the statute to make sure that it wasn't just considering structural damage a crack in the stucco versus one of the 5 now enumerated categories, which is what structural damage needs to be. And frankly, Your Honor, Fajardo, I went back in that case. First of all, it's a per curiam affirmance that's been relied upon by appellee in this case, but also it's factually and legally different. And if you look at the brief, I went back and dug through the brief, which really, I guess we didn't need to do since it shouldn't be relied on, but page 23 of the answer brief, and it's at record 6435, even the appellee, the insured in that case, admitted that only sinkhole loss coverage requires structural damage. The problem with that case in Fajardo, there was additional damage. There was water damage that fell outside of the scope of the sinkhole loss coverage endorsement. So in Fajardo, factually and legally different to what we have here. In this case, we have a clear case that involves sinkhole loss, period. And if there's any question with respect to that, record page 4336 is plaintiff's witness list, where they identified Sunny Gulati as their engineer to testify regarding the cause of damage, and I quote in parentheses, sinkhole activity. He'll testify that the damage to the property was caused by sinkhole activity and qualifies as structural damage in accordance with the statute. During plaintiff's opening statement in this case, and it's at record 6785, and I quote, "This case is about a sinkhole loss that occurred that the evidence will show occurred at the Barberins' home in January of 2013. And then if you look at the plaintiff's direct testimony with respect to the damage, they talk about the stair-step cracks in the interior and on the walls from record pages 7032 to 7038. That this case that we're dealing with here is exclusively and specifically a sinkhole loss case. There is not going to be any other type of damage that would fall outside of the sinkhole coverage endorsement that we're dealing with in this case. So for plaintiffs to come in and have a jury instruction that states that they need only prove that damage occurred during the policy period is an incorrect statement of law, and it's confusing and misleading. And it did actually confuse and mislead the jury in this case, because we had a jury question during the deliberations, and this is record 6511, where the jury asked about physical damage. They were, quote, looking for physical damage defined. There was never a definition of physical damage. So what the jury was attempting to do, Your Honor, is what we're saying that the court should do in this case, and what the law supports, is that the plaintiff, the insured, has the burden to establish that the loss fell within the terms of coverage under the policy, whether it be all risk or not. And if their burden is to establish direct physical loss in the context of sinkhole, which is what we're dealing with here, they have to show that it was caused by sinkhole loss, which was defined as structural damage under one of the 5 enumerated terms. And the plaintiff has acknowledged this, yet they still want to hold on to this concept and this mantra that's developed, that all they need to do is show that there was damage during the policy period. But Your Honor, that works in the scope of the general home HO3 policy. It doesn't work in the scope of the sinkhole loss coverage endorsement. And I do believe that that's consistent with Mejia and the court's concurrence, where Judge Altenburn even said that this policy has developed since the 1970s, when all risk policies were developed. It has become an amalgam that is neither an all risk nor a named peril form. And he ended his concurrence by saying, the only practical solution as to the specific issues raised in a sinkhole litigation is to place the burden of proof on the insurance company once the insured has established the requisite physical damage to the insured dwelling during the terms of the policy. And so, Your Honor, Mejia, this case can conform with the holdings and the dictates of Mejia. There's nothing to recede from here. We're just dealing with an entirely different statute. And in order for the insured in this case to show the requisite physical damage to the insured dwelling, they have to do more than just show damage. They have to be able to show that the direct physical loss was caused by sinkhole loss, which is structural damage in this case. And if Your Honors have no more questions, I'll hold my time for rebuttal.
Well, you won't be able to hold the 5. You're only at 12 now. So that would be 8 minutes. So
Yeah, 8 minutes.
it's kind of in this position, you may want to use it. I don't mind if it goes longer. With Ms. Delegate, give you some of that time back, but I'll leave that to your discretion. I'm not going to give one side,
Your Honor, I think that for the panel, I think I've made my points pretty clear amongst the argument and the briefing. The jury instructions in this case were misleading. They did not accurately define what the plaintiffs had to do to establish a direct physical loss. Citizens' instructions did ultimately properly define this. If I'm looking at record 6060 and record 6056, Citizens wasn't placing an ulterior burden on the plaintiff. What they were doing is indicating that the plaintiff had to show that Citizens breached its policy of insurance with plaintiffs regarding structural damages caused by sinkhole activity. So, Your Honor, we do believe that the trial court erred in this respect. With regard to our second issue and the admissibility of the neutral evaluators report.
Before you go there, let me go ahead and let's talk a little bit more about Mejia, because I'm not sure I agree with your characterization of Judge Altenburn's concurrence, because he says that he concurs in the opinion and would do so even if the policy were not treated as an all risks policy. And then he goes later in the concurrence and talks about where sinkhole damage is excluded in the main policy, revived in the endorsement, and then litigated as a matter that is either covered sinkhole damage or excluded earth movement damage. It seems to me the only practical solution is to place the burden of proof on the insurance company. So I'm not exactly sure why you're telling us that Judge Altenburn's opinion supports your position.
Well, Your Honor, it does, again, one, because we're dealing with a different statutory provision now, but two, Judge Altenburn is recognizing the fact that the all-risk policy has evolved since it was first incepted. So
But
back
then
in
he
the
shows that he would still concur in the decision, even if the policy was not an all-risk policy.
certainly, Your Honor, because
That's the first sentence in his concurrence.
correct, but in Mejia, the only thing that the plaintiff or the insured needed to establish was evidence of direct physical loss that was caused by sinkhole loss. There was no definition of sinkhole loss. Sinkhole loss was there, whatever it was defined as, direct physical loss. So there wasn't anything attached to that. Now we have a definition attached to sinkhole loss that involves more than merely showing there was damage. Plaintiff, who has the burden to establish coverage under the policy, has to show that their loss falls within direct physical loss for sinkhole loss defined as structural damage. They have to establish more than just, I have a crack in my building. And whether that be, and I'll take this a step further as I was just
If
addressing.
you're going to take it a step further, let me let you know that we have gone past 15.
I'm sorry,
We have exceeded 15, so as you're going for a step further, let me let you know.
I'll take a step further and then I'll reserve the rest of my time. To take it a step further is if plaintiff only has to show on their initial burden that they have a direct physical loss and Citizens shows that it falls within a policy exclusion, there still needs to be some evidence that brings it back within coverage. At some point, there has to be a showing on the plaintiff side that there is coverage for structural damage as defined by the statute. The legislature intended that without getting into the statute too much. It would eviscerate the intent of the statute to just say there's these definitions and nobody has to establish anything that falls within the definitions. And with that, I'll reserve my time. Thank you.
Thank you, please. Thank you. Thank you all for your patience, Mr. Elliott. You may respond.
Thank you. Good morning. May it please the court, Tom Elliott on behalf of the Barbarans. I think there are a couple ways you can look at this, and the court's sort of done both of them. Let me start with the historical perspective of the case law, because as Judge Black noted, there are about a half a dozen cases of recent times on this, recent being the last since Mejia and Munoz. And I don't want to overlook Munoz because Munoz, Judge Kuzam wrote that opinion. Okay, and then Judge Kuzam is on Fajardo in 2021, which is the last case that I know of that addressed this. And Fajardo cannot be distinguished on the grounds that there was also a claim for some other loss there. If you look at the briefs, if you look at the argument, if that's still available, you can see that Fajardo focused on this exact issue. And Judge Kuzam and Judges Smith and Stargell rejected that there, and we would urge that we should stay the course, so to speak. And the more now to switch over to why is that, and even if you didn't have those cases, why is what's being argued today by Citizens wrong? We have a situation, and in Mejia, to go back to Judge Silverman's point, in Mejia, it did require sinkhole loss, and it required structural damage. The only thing that has happened since Mejia and Munoz is a different definition, or an additional definition of structural damage. Structural damage has been required since 2006, so it was required in Citizens and Mejia, Munoz, Fajardo, and a couple in between. So it has always been required. What the difference in the definition does, again, you start with the premise, and it's not a mantra, maybe it is, it's the premise, it's the law, that in an all-risk policy, which this is, the insured shows damage within the policy period, then the insurer must have the burden to show it is not covered. Now, one way the insurance company could do that is to say that, well, this sinkhole coverage you have, which they did pay an additional premium for if you look at the beginning of the policy, that's you didn't trigger it or it's not, or we can show it's not triggered because we're going to show this is not structural damage. And we have these 5 definitions, and we're going to show you didn't come within them. What does that do? That made it easier, theoretically, for the insurance company to show, oh, look, there is no structural damage, and hence there is no sinkhole loss. But it's still the insurance company that has to show that. The legislature, I mean, burden of proof has been an issue since at least 1984, when we have the Hudson decision from this court. The legislature knows that. The legislature, if you're going to change burden of proof, something is significant in the case law for 40 years now, they would have done something. They wouldn't do it in a backhanded way of saying, oh, well, look, we're going to change the definition, and we're going to tweak the definition, which has been there for a long time, since 2006. They would have said, oh, and by the way, under the sinkhole loss coverage, the insurance company should not have the burden of proof anymore. Now the insured should have the burden of proof to trigger that coverage. They didn't do that. So Citizens, in a sense, is asking you to legislate, which we know you don't do. And again, it may help them, but it doesn't change the law, and it doesn't change their burden. And given that, the jury instruction was correct. It was an exact correct statement of the law that this court has had for 40 years. I didn't hear anything else.
The court in Munoz relies on Hudson, indicating that there's been no real change in that interim period. Munoz relies on Hudson.
Yes. And again, adding a definition or redefining something doesn't change the burden of proof. That's way too subtle a way for the legislature to do something that's significant. And yes, Your Honor, if what you're saying is it's a correct, definite stream forward and consistent, yes, I would agree with that. And I also agree with Judge Silverman's point that if you look at Judge Altenburn's concurring opinion in Mejia, he's saying, look, as a practical matter, we need to put this burden on the insurance company. That's what the law does. That's what the law has done for many years. And again, the change in definition, maybe it makes it easier for them to say, hey, look, we can show there's no structural damage because our expert's going to testify that didn't meet these 5 things. And the plaintiff's experts, in this case, and the defendant, Citizens had 2 experts opine to that, and the jury agreed with the plaintiff's expert. That's a factual dispute that was resolved. I would also suggest this really isn't preserved either for Citizens, because if they thought structural damage was so important and they didn't get the instruction they wanted, they should have asked the judge to put a special verdict question on. Was there structural damage? Then you'd have had an answer to that question, and you wouldn't even have to rely on the burden of proof question or issue. But they didn't do that, so they could have saved it. They didn't preserve it. If there are any questions on any of the other points, I'm glad to try to answer those. Otherwise, say Citizens is asking this court to ignore the court's repeated correct holdings that Citizens has a burden of proof to show the loss was excluded, including the Fajardo opinion on the exact same policy language. We would ask that you affirm. Thank you.
Thank you, counsel. I don't see any questions. I thank you. Attorney Andrew, you have 4.5 minutes remaining. Before we start, I do have a question. Based on your last comment, I think before the time expired, you mentioned it was the legislative intent. My question is, was that comment directed to a shift on the burden of proof? Because as I understand it, we are at supremacy of the text state now. And I didn't see anything in the legislation or in the statute that specifically addressed a change in the burden of proof. Or does this undergird your argument that a more refined definition of burden of persuasion that doesn't exist. I want to make sure I'm clear on that. And I knew it was going to take me a while to ask the question, and I didn't want to pick up all of your 4.5 I asked you the question. So thank you, if you would begin.
Thank you. The legislature was attempting to curb the number of sinkhole claims that were made. And it was a legislative change to the statutory definition of structural damage because the intent was to limit the number of claims made for sinkhole. Now, Your Honor,
Was it intent to change the number of claims or change the number upon which the insurance company had to pay out? It's
Probably.
kind of hard to stop people from going to the court.
kind of hard to stop. I agree with that, Your Honor. But regardless, this is not a burden. This is not a change to the burden. The burden of proof has always been with the insured to establish coverage. And they have to show that there was damage within the terms of the policy. And that goes all the way back to at least the Hudson versus Prudential case in 1984. And here, regardless of whether we're considering it an all-risk policy that's a traditional all-risk policy, an amalgam of an all-risk and a named perils policy, or however we're classifying the policy terms, conditions, exclusions, and limitations to bring sinkhole loss within coverage, there has to be evidence of structural damage. And it's the plaintiff's burden, the insured's burden to establish this, and it always has been. This isn't a change of the plaintiff's burden. It's a shift in the quantum of evidence necessary to satisfy a burden, but it doesn't shift the burden to the plaintiff to establish coverage, which has always been on the plaintiff. The statutory change in 2011 was significant. This is the first case that the court has really had where there's still an opportunity to write on it. Again, Fajardo, it's our position that it's inherently different from this case on the facts, which have additional damages outside the scope of sinkhole loss, but also because the court didn't write on it. So we don't know why the court declined to write on it and just per curiam affirmed, and it could be based on the factual differences. Here we have jury instructions that did not accurately define the law, and they were also very confusing and misleading, notwithstanding that, because we had a definition, we had a question regarding direct physical loss, and then we had a definition of sinkhole loss and structural damage that was just outstanding and hanging in the jury instructions. It didn't do anything. The jury was confused by what physical damage was, and it didn't know what to decide on the verdict form because that was the only question that it was asked. So in conclusion, Your Honors, what we're requesting that this court do is to acknowledge that an all-risk policy is not an all-loss policy, that the insured must still present a prima facie case of coverage, and this requires at a minimum a quantum of evidence that's sufficient to meet the policy terms. Here we have policy terms that require direct physical loss and evidence of sinkhole loss that is defined as structural damage within the statutory enumerations. And we're also requesting that this court reverse and remand because the trial court committed a reversible error by providing jury instructions that did not contain an accurate statement of the law and which were confusing and misleading. So thank you.
Thank you, counsel. Thank you both. That will conclude this case before the court. And I will let you transfer, however they do it, electronically, electrons, to the other resting place. You're more than welcome to watch or